Imagine this, a man worth over $13 million dies suddenly in Sydney. No signed will, no witnesses, no lawyer-prepared document. But investigators discover something unusual. Inside his iPhone Notes app, there is a document titled Last Will of Colin L. Peake. It divides up his entire fortune. Most of the money goes to his close friend, a smaller portion goes to his brother. The question becomes, can a note on iPhone legally become a will? At the first instance, the judge ruled the iPhone note was only a draft, not a valid will. But then the case went to the New South Wales Court of Appeal. Today we will break down the background story behind the dispute, the key legal issues on appeal, and most importantly, what this means for ordinary Australian, regardless whether you are going to inherit assets from or leave assets to your family and friends. Because like it or not, this will happen to you one day as a matter of time. The man at the center of the dispute, Colin Peake, was a 79-year-old Sydney businessman, a successful property investor. After finishing year 12 in around 1960, Colin worked at Commonwealth Bank of Australia for a few years. At the age of 21, Colin started working as a chicken sexer in a farm, and during this period, he lived with his parents. He worked hard and saved enough money to purchase a Cooper S model car, and he also bought 30 acres of land in Marsden Park for $20,000. Yes, that was the price about 70 years ago. For the next period of 30 years, he managed to acquire a number of properties, participated in various development projects, and made a fortune. By the time of his death, he was the owner of an estate worth about $13.6 million. He had no surviving spouse, child, or parent. Colin had several long-term relationships, but none of them resulted in any marriage at the time of his death. His assets include $6.2 million cash, property development interest of about $5.6 million, loans to friends of about $1.4 million, some luxury cars, watches, and personal items. But despite his wealth, he never signed a formal will. Two people become central to the dispute. Ronald Peake is Colin's brother, and is the Colin's only close family member that was still alive. He's the plaintiff in this case. Colin and Ronald were raised in Randwick, and both went to Randwick Public School. Ronald was Colin's best man at his wedding in 1966, and Colin was Ronald's best man at his wedding in 1959. Brad Wheatley is a close friend of Colin. He's a real estate agent, and they met each other in 2003 when Colin sold one of his properties. They then became close friends, and to Brad, Colin was like his mentor. Evidence indicated that Brad had daily contact with Colin and often visited his home. He's the defendant in this case. According to Brad's evidence, Colin told him in August 2022, just before his death, that he would like to make Brad as the executor. Colin did not want to leave his estate to his brother Ronald and said to him, "I don't want his son Aaron or his wife getting any part of my wealth when I'm gone." Colin also said to Brad that he regarded Brad as not only a mate, but in so many ways the son that he lost. On 21st July 2022, Colin met his solicitor, Mr. Peter Dawson. They have known each other for a long time because in 1997, Peter had donated his legal services and Colin was the successful bidder. Colin told his solicitor Peter that he did not feel well and he had been waking every night at around midnight. The solicitor told him bluntly, "You need to make a will." Colin replied, "I will write it down and send it through." In that conversation, Colin mentioned that he would give basically everything to Brad, but he would leave the Mercedes vehicle to Ronald. This conversation was recorded in Peter's file notes, but Colin never sent formal instructions. After this meeting, Colin returned home and complained to his cleaner saying, "I need to do something about my will. I'm not sure what to do, but there is no way Aaron, being the son of Ronald, is driving my cars or getting Rolexes." On 3rd August 2022, Brad cooked a dinner at Colin's house in Bella Vista, as he frequently visited this millionaire during his last stage of life. In the midnight at 12:30 a.m., however, Colin experienced a severe medical emergency. and called 000 asking for ambulance. Brad helped Colin downstairs, brought him some mango juice. At 2 a.m., paramedics arrived and warned Colin had come close to a diabetic coma. By that time, Colin had consumed about 1.5 liters of juice and smoked several cigarettes. He declined to go to Norwest Hospital and said he felt better. That moment changed everything. The next day, 4th August 2022, something critical happened. At 4:25 p.m. on 4th August, Colin created a document in his phone titled Last Will of Colin L. Peake. It listed how his estate should be distributed. Here's key information typed in his phone. Firstly, most assets including house and balance of accounts would go to Brad Wheatley. Secondly, about $990,000 would go to his brother Ronald. Thirdly, smaller gifts would go to his friends, including $50,000 cash to his cleaner who worked for Colin for over 13 years and later gave evidence in court. Colin even gave 5% to his solicitor, Peter Dawson. But the document had no signature, no witnesses, and no lawyer's involvement. Evidence shows that Colin spent quite some time doing this note. He closed the note at 1:35 a.m. on 5th August, being almost 8 hours after he started the note. After he finished typing, he never reopened this note again. Just 12 days later, Colin died in his sleep. When the solicitor searched his house, he found the iPhone note, and that note triggered a multi-million-dollar legal dispute. Was the iPhone note a real will or just a draft idea? That was the entire lawsuit. There were two competing legal positions. Brad Wheatley argued the iPhone note was Colin's will. He applied for probate based on that document. Ronald Peake argued the note was only a draft or reminder. Therefore, Colin died without a valid will. Under New South Wales succession law, that would mean Ronald, as Colin's closest family member, could apply for letters of administration to inherit the entire estate. So the entire case turned down one question: did Colin intend the iPhone note to operate as his will? Australian law normally requires strict formalities for a will. Under Section 6 of the Succession Act 2006, New South Wales, a valid will must be in writing, be signed, be witnessed by two people. Colin's phone note satisfied none of these, but there is a powerful legal exception. That is the informal will rule. Section 8 of the Act allows court to recognize informal documents as wills, even if they are unsigned, unwitnessed, digital, and handwritten notes. Courts can validate them if these three conditions are met. Firstly, there must be a document. An iPhone note qualifies as a document. Number two, the document must state testamentary intentions, meaning it must describe how property should be distributed after death. The note clearly did so. Number three, a key test is, did the deceased intend the document to operate immediately as a will? This third element is the most difficult. Many people write out proposals for their wills on pieces of paper headed will, but often these are not more than present thoughts, not testamentary intentions, and certainly not intended to be wills. Courts must decide whether the document was a final will or merely a draft or preparation. The case was initially heard by Justice Mark Richmond in the Supreme Court of New South Wales. He ruled that the note did not constitute a final will, so Brad appealed. The Supreme Court of New South Wales Court of Appeal heard the matter, and Chief Justice Andrew Bell, Justice Anthony Payne, and Justice Anna Mitchmore were required to determine whether Justice Richmond's findings should be overturned. So how do judges determine the intentions of someone who has already died? They examine every piece of surrounding evidence, and several facts suggested the note might be a will. Firstly, looking at the title. The document was explicitly called Last Will of Colin L. Peake. This suggested a testamentary purpose. At the time, Colin was very sick and his health conditions need to be considered, as mentioned in previous court precedent. Another way of looking at this is whether the deceased thought that was the only way a valid will could be created. The note was prepared shortly after Colin's near-death experience in the early hours of 4th August. leading towards a conversation between him and Brad, who told Colin to make a will. These factors present strong reasons in support of the testamentary purpose. The Court of Appeal considered that the document was intended to operate as Colin's will because the date was included, his initials CP were included, and that functioned as a signature in the context when it was written. Number 2, detailed asset distribution is required. The note divided property, named the beneficiaries, and appointed an executor. These are typical features of a formal will. Although the trial judge thought the document missed major assets, the Court of Appeal concluded that the note covered most assets, including Colin's house, bank accounts, vehicles, business interests, loans, and joint ventures. The document even ended with the words, "No one else gets a thing." The Court of Appeal said this indicated Colin believed he had fully distributed his estate. Number 3, statements to friends. One witness testified that Colin said, "I've finalized my will." This statement was made about 1 week after the note was created. The statement was clear and unequivocal that he had finalized his will, not that he had finalized the draft or instructions to solicitor to prepare a will. This supports the conclusion that Colin intended the note to have operation as a will. The other friend to whom Colin lent a lot of money and a mortgage testified that Colin told him that he would record his wishes with his solicitor and said, "You will not have to worry about your mortgage. I will be forgiving it to you." In the same conversation, Colin said, "Brad will get a lot." Most of these friends gave evidence that Colin had mentioned to them that he would not leave most assets to his brother, and Colin treated Brad as his best friend who gave major support at the end of his life. However, other facts raised serious doubts. First is about the solicitor's conversation. When Colin spoke to his lawyer on 21st July, he said, "I will write it down and send it through." That suggested the note might only be instructions for a lawyer, not the final document. Number 2, lack of follow-up. Even after creating the note, Colin never sent it to his lawyers, never printed out, never told most people about it. Evidence indicated that Colin had a few calls with Brad after creating the note, and he had the opportunity to tell Brad about the note, but Colin chose not to do so. The trial judge pointed out that by not telling everybody the existence of such documentation, there was a real risk that they would never find it. The Court of Appeal, on the other hand, said that Colin at least implied something on 13th August during a telephone discussion. On that date, Brad had looked at one-bedroom apartment and sought Colin's support to buy it. In the telephone, Colin told Brad to wait and not buy or inspect any one-bedroom apartment, and said, "You won the lottery the day you met me." Well, no one now can dispute that Brad did hit the jackpot after he won the case and inherited most of Colin's assets. Number 3, the missing phone data. After Colin's death, experts found that emails, messages, and phone data had been deleted from the iPhone. Brad admitted that he went back to Colin's place after police left. He took the phone police officer placed in a desk drawer and charged the battery. But the expert discovered that certain data was removed since Colin's death. Since Brad had the fingerprint lock access to the house, he's the only person that could cause the data removal. During cross-examination, Brad said that he usually would delete spams, but he could not explain why certain emails, such as the email attaching the note sent by Colin's solicitor on 19th August, was also deleted. This created uncertainty about whether other evidence existed that would harm Brad's case, but such evidence was destroyed. But the Court of Appeal said there was no evidence the deleted messages related to the will. Speculation could not replace proof. There are also some credibility concerns. The trial judge criticized the role of Colin's solicitor, Peter Dawson. The solicitor helped prepare witness affidavits, was also a beneficiary in the will, and acted for Brad as a defendant. This created a conflict of interest. The solicitor was said to have crossed the line. The trial judge said this situation reduced the reliability of some evidence. During appeal, however, the judges considered Colin's solicitor's conflict of interest did not affect the key issue. There was no evidence that Peter Dawson created the note or influenced Colin's decisions. The Court of Appeal said the focus must remain on Colin's intentions, not the lawyer's behavior. The ultimate question is whether Colin intended the note to operate without more as his will, or was it merely a step toward making one later. That question determined the outcome. The Court of Appeal eventually held that the iPhone note was a valid informal will. Brad Wheatley was recognized as the executor. Probate of the iPhone note was granted. In other words, the digital note determined the fate of a $13 million estate. Could your phone note or text message become your will? The answer is surprising. Digital wills are becoming real. Australian courts have previously accepted and sent text messages, Word documents, phone notes as informal wills. This case continues that trend, but the risks are enormous. Without formal wills, families face multi-million-dollar litigation, destroyed relationships, and chance of losing the entire estate to somebody that may not be an intended beneficiary. The court repeatedly emphasized that informal wills are exceptions. The safest approach remains the same, that is, one needs a properly executed will, witnesses to sign the will, and clear instructions are given on how assets are to be distributed. I've assisted clients with their wills and estate matters for over a decade. If you want to have a free legal consultation on your will or estate matter, you may send an email to info@mgam.com.au so that we can refer you to a lawyer. Now, why this case matters? For ordinary Australians, the case shows your digital life can now influence inheritance law. By relying on phone notes or emails is extremely dangerous. Cases like this raise fascinating legal questions. So here are some questions for you to think about. Should Australia introduce clear laws for digital wills, rather than leaving it to the court battles? Or this unorthodox way will open the floodgate and create more disputes? Let me know your thoughts in the comments. If you want to learn more about recent interesting cases, please like, subscribe, and share. Thanks for watching. I'll see you next time.